Welcome in, everybody. Thanks for tuning in. It's excellent to have you here as always, and thank you for watching. I've heard from many of you that something's up with the way the YouTube's is operating. Many of you reported that you've been outright unsubscribed. The notification settings have been changed around without your knowledge, or we're just not showing up in your feed. If you're not seeing 3 to 5 videos from this channel a week, then something's amiss. Go check your notification settings, go check your subscription status, etc., etc. Just because you saw this one doesn't mean that something's not messed up. Also, while you're on that whole thing, please interact with the video in some way. It helps tell the machine that more people need to see this video. So the question for today's video is, Kurt, for like 2 solid months, we got consistent updates every other day, every 3 days, something like that. Something was going on with the pistol brace regulation. And now for like the last 3 weeks, we haven't heard anything. What is the status of the pistol brace situation? And where's it going? What's going to happen? Sorry for the weird cut there. I was actually planning on filming a completely different video, just an update video, but now I refreshed the page and we have an update from the Fifth Circuit Court of Appeals. I'm going to take you right there. The plaintiff sued for injunctive relief, alleging various statutory deficiencies with the process and substance of the final rule. They also brought constitutional challenge. The district court denied injunctive relief, and after it did not rule expeditiously on a motion for injunction pending appeal, the court enjoined enforcement of the final rule against the named plaintiffs. Plaintiffs now request that we extend that interim relief. We reverse the denial of an injunction because plaintiffs will likely succeed on the merits of their Administrative Procedures Act challenge. We remand with instruction to adjudicate the remainder of the preliminary injunction factors and determine the scope of any relief. What that means is, lower court, sorry, you're wrong. Fix this and fix it this way. This little nugget here talks about how the NFA was ridiculous on its face and just a tax scheme brought up by the government. No one was under any misconception that gangsters would obey the strictures of the NFA. We move on the plaintiff's claim that the final rule violates the APA's procedures and substantive requirements. On that front, plaintiffs established a substantive likelihood of success on the merits. The ATF incorrectly maintains the final rule is merely interpretive, not legislative, and thus not subject to the logical outgrowth test. What they're referring to there is, if you listen to the oral arguments, which I do suggest that you do, it's about an hour and a half. You got to drive or something like that. It's a good listen. It's really easy to tell when the government shows up to do their testimony and when the plaintiffs are talking. So our side versus their side, very wheedling on the side of the government. And basically what they're referring to here is the attorney for the ATF was basically like, well, we were just kind of spitballing. We didn't actually, we were just trying to tell everybody what we were thinking. And the judges didn't buy it. The final rule affects individuals' rights, speaks with the force of law, and significantly implicates private interests. Thus, it is legislative in character. Then, because the final rule bears almost no resemblance in manner or kind to the proposed rule, the final rule fails the logical outgrowth test and violates the Administrative Procedures Act. Multiple judges within this circuit have already issued injunctions against the final rule, following the initial one issued here, enjoining enforcement against members of various gun rights organizations. It is already uncertain how many persons are now subject to these injunctions or how the ATF would enforce the final rule against non-enjoined parties. There is a need for consistent application of law, and the court may not have all of the required facts. Accordingly, the district court is better situated to weigh the facts and fashion the most appropriate relief. For the foregoing reasons, we reverse the order denying preliminary injunction and remand with instruction to consider the motion expeditiously. To ensure relative stability, we maintain the preliminary injunction pending appeal that the motions panel issued on May 23rd, 2023. And then because it was going to expire within 60 days, they tell the district court to figure their crap out before it expires. We place no limitation on the matters that the conscientious district court may address on remand, and we give no indication of what decision it should reach regarding a preliminary injunction or any other matter. I have a feeling that that has to do with some of the NFA challenges that the court was wrestling with during oral arguments. So to decipher all this for you, the Fifth Circuit says, okay, well, there are a bunch of challenges to this rule. in a couple different ways, constitutional arguments against it from Second Amendment, a few other things, and then Administrative Procedures Act. You guys clearly violated the Administrative Procedures Act when you did this, and because of that, lower court, you're actually wrong. So we're sending this back to you with the guidelines that we have outlined in this case, saying that, yeah, you were incorrect in your analysis. So here are your guidelines for getting that right the second time around. Here's the case back, because we could issue a nationwide injunction, but we've decided that we don't have all of the individual facts of each individual case, and therefore you guys are better situated to handle all those. So what that means is all those cases that are sort of on hold waiting for the Fifth Circuit to kind of figure out what they wanted to say about it are probably going to restart now. So you'll probably see a lot of traction on all of those individual cases, particularly the ones that are controlled by the Fifth Circuit. Probably going to see them restart here pretty soon. Maybe on the ones that aren't directly controlled by the Fifth Circuit. So keep in mind that we will be providing you updates whenever we get them. This is the best that I can do. I can only work with the information that I have. I want to know what you guys think is going to happen in the comment section down below. And thank you for joining us here today on the VSO Gun Channel. Hopefully we'll see you on another one here pretty soon.